Did he examine any proposed plans?
Are you asking about the defendant's backyard or the plaintiff's workshop?
The workshop. So not their backyard, right? The workshop plans.
But, and here's, again, here's where I think, I'm not sure if we're getting confused. This,
right? The workshop plans.
but, and here's, again, here's where I think, I'm not sure if we're getting confused. This permit issue here, but, and here's, again, here's where I think, I'm not sure if we're getting confused. This permit issue here that we're discussing for the motion to quash has nothing to do.
It's two parts. It's permit for the boxes.
Right.
Right? But it's in the same category as to the permits to the workshop. Because any inference would have applied equally. What's good for Peter is good for Paul.
Well, I understand that, except the issue with the motion to quash originated as the fact that the subpoena itself was improper.
I understand that.
Okay.
So that's a procedural issue, right?
Right.
And it's a procedural issue because, and we went down the road about the custodian of records and who adequately has the information, and I found that they don't have the information. They cannot provide something that does not, exist. So that issue on the procedural side, I think we all align, I think. But on this, you don't think?
Well, if you're, it depends why you're denying the motion to quash, I guess. Because
the motion to deny can be quashed on two bases. I'm trying to get to the substantive portion that impacts the elements of the case that the plaintiff has to establish. So here, look, whether a permit was necessary for this goes to both, it goes mostly to the causation element of it. That's where I'm looking at it. But the substance of this, the substance of it, can equally apply to the workshop as it can the plotter, or the planter rather. And so what I'm trying to get to here in your witness is they're going to come and talk about examining plans for the planter and for the workshop. Is that right?
not for the planter.
I am the fact finder. The plaintiff has to have the burden here. I need information from these witnesses, and if the line of question is not getting to the actual relevant elements as I see it, what use is that testimony? It's not very useful. And maybe I would give you a little bit more leeway if it were a jury so that you can help inform the jury. Is not getting to the actual relevant elements as I see it, what use is that testimony? It's not very useful. And maybe I would give you a little bit more leeway if it were a jury so that you can help inform the jury. But this case, boy, I know more about this case than I know about any other case, just about. And so I'm here to see if the plaintiff meets their burden and whether you foresee, hey, if this defense is not being asserted, we don't need to talk about that, right? Or if this cause of action isn't being adequately addressed, then I have to say, hey, can you please ask questions about this? Because as the finder of fact here, I need to get to a record that adequately supports whether I find for you or I find for you. So, back to the top.
Yes.
Motion to quash is denied, and it's denied on those procedural elements that I outlined. Now the second thing, if there is something to the substance where we're getting into some type of speculation as to the permitting, you are allowed to object. But be mindful that I will make a ruling right at the spot rather than doing a sidebar or waiting, unless something unexpected comes up, and you'll bring that to my attention, okay?
Okay.
Alright, so, next issue. Anything remaining from the FSC?
There's still motions in limine that have not been discussed, and
Let's
then
talk about those.
there was our request, because you asked that I make a formal request for Alan Wallace to testify via LA court. So I
I did
submitted
get that. I got that. So Wallace can submit via court connect. We left it, or is it the same? Any changes to what we left it, or is it the same?
I believe it's,
Okay.
I've made no changes. We only have one plaintiff has.
We left it, or is it the same?
I believe it's,
Okay.
I've made no changes. We only have one plaintiff has. I've made no changes. We only have one.
We left it, or is it the same?
I believe it's,
Okay.
I've made no changes. We only have one plaintiff has four, I believe.
Alright, so,
I've made no changes. We only have one plaintiff has four, I believe.
alright, so, let's bring up the motions in limine. Where can I find the motions in limine? In the paperwork I have before me. I have the joint exhibit binder, I have the trial binder, is it in the trial binder?
I don't believe they are, Your Honor. They're quite thick. We submitted courtesy copies of defendants along with a notice of lodgment for expert. Legal, anything, it's just their demand for disclosure, our demand for disclosure, their designation, our designation, and then our supplemental designation.
Okay, so let's talk about the
Their expert, Brad Stern, declaration on the penalty of perjury pursuant to CCP 2034-260. It is only a statement. Opinion on all of these things.
On all of the valuation?
On each of these sentences, some of them broken down. It is exhibit 1 to my declaration in the motion.
All right, let's go there, please. Brad Stern is a certified general real estate appraiser and licensed California real estate broker with over 25 years of experience in the appraisal, analysis, and consulting of commercial, industrial, and residential real estate throughout California. He is affiliated with MCS Associates and is based in West Los Angeles. Mr. Stern industrial and residential real estate throughout California. He is affiliated with MCS Associates and is based in West Los Angeles. He is affiliated with MCS Associates and is based in West Los Angeles. Mr. Stern has served as an expert witness in numerous real estate valuation matters, including disputes involving undeveloped or partially developed structures. Mr. Stern has served as an expert witness in numerous real estate valuation matters, including disputes involving undeveloped or partially developed structures. In the matter of Thomas Bashura et al., Mr. Stern will provide expert testimony regarding the real estate valuation implications of not yet constructed accessory dwelling unit that has been delayed due to a civil dispute. Specifically, Mr. Stern will address how alleged drainage obstruction and flood risk caused by a structure built by the defendant has impacted the plaintiff's ability to develop the ADU on his property in Glendora, a location approximate to a designated flood zone. Petitioner's testimony will focus on the valuation of the subject property with and without the ADU, and the diminished value or loss of development potential resulting from the obstruction, and any broader market impacts associated with drainage and flood concerns. So what did he give an opinion to?
His testimony was, and just so you're on the nose, I attached the relevant portions of his deposition transcript to our motion in limine, showing that I asked him line by line whether he had an opinion on all of these things.
On all of the valuation?
On each of these sentences, some of them broken down. It is exhibit 1 to my declaration in the motion.
All right, let's go there, please. Giving an opinion as to real estate value implications of the yacht deck constructed accessory dwelling unit, as the constructed accessory. So we'd be giving an opinion as to real estate value implications of the yacht deck constructed accessory dwelling unit, real estate value implications of the yacht deck constructed accessory dwelling unit, as the delayed due to a civil dispute. The answer is no.
Correct.
Giving an opinion as to real estate value implications of the yacht deck constructed accessory dwelling unit, as the delayed due to a civil dispute. The answer is no.
Correct.
Will you be giving an opinion on constructed accessory dwelling unit as the delayed due to a civil dispute? The answer is no.
Correct.
Will you be giving an opinion on how the alleged drainage obstructions and flood risks caused by a structure built by the defendant has impacted the plaintiff's ability to develop an accessory dwelling civil dispute? The answer is no.
Correct.
Constructed accessory dwelling unit as the delayed due to a civil dispute? The answer is no.
Correct.
Will you be giving an opinion on how the alleged drainage obstructions and flood risks caused by a structure built by the defendant has impacted the plaintiff's ability to develop an accessory dwelling unit on his property in Glendora? The answer is on how the alleged drainage obstructions and flood. Will you be giving an opinion on how the alleged drainage obstructions and flood risks caused by a structure built by the defendant has impacted the plaintiff's ability to develop an accessory dwelling unit on his property in Glendora? The answer is no. Will you be giving an opinion on the valuation of the subject property with and without an accessory dwelling unit? Half yes, half no.
And I think I asked why, and I believe that's important to the analysis.
He's here to solely discuss valuation. That's the expert designation. Here, the difference between a workshop and an ADU, as it relates to valuation, he can discuss.
He could, except he gave no testimony
Mr. Thomas's property. Objection. Ms. case, as we found with them, relate to Mr. Thomas's construction. Okay, Mr. Stern, your opinions in this case, as we found with them, relate to Mr. Thomas's construction of a workshop on his property. In this case, as we found with them, relate to Mr. Thomas's construction of a workshop on his property. Is that accurate? In this case, as we found with them, relate to Mr. Thomas's construction of a workshop on his property. Is that accurate? Yes. So, I disagree with you. I think and let me explain to you why I disagree with you. He knows what an ADU is. Here's my ruling, and then I'm not going to take any more. So this person here is a valuation expert, purportedly. That's what the designation that I just read. Here he states he understands what an ADU is, and we are not an OT dealing with an ADU. And we are dealing with a workshop. He can testify to the fact that there is a difference in valuation from an ADU from a workshop. And whether the valuation is any different for a workshop, he can expound on. Of the property that is not going to have an ADU is going to have a workshop as to any differentiation between that. Like, from my mind, I understand your those differences and whether there's any effect on valuation, because
expert designation not complying with CCP 2034.260, in that it is not a declaration. Their expert designation not complying with CCP 2034.260, in that it is not a declaration under penalty of perjury by either of counsel as required by that code section. It is simply a pleading that they happen to say, in that it is not a declaration under penalty of perjury by either of counsel as required by that code section. It is simply a pleading that they happen to sign. It does not include the hourly rate of the expert. It does not include a statement that he will be that he's agreed to testify at trial, nor does it include a statement that he will be ready and prepared to testify regarding these specific opinions at a deposition.
But I think the relief that you can ask for,
Okay.
I have a wide ambit of relief that I can ask, that you can ask. Ask this witness very few questions based on what he ultimately testified in the deposition.
Okay.
Now, that limitation doesn't necessarily apply to you. So what relief did you ask for in your motion now that you have my partial grant and my partial denial?
Well, the relief was that he be excluded from testifying entirely.
But you know that I've ruled against you on that. You've asked for an extreme, but this is like a staircase, right? There are, depending on my ruling, there are different elements that you can then ask the court for. So I have partially granted and I have partially denied motion to eliminate, defense eliminate number one. You're asking to exclude him in its entirety. And I'm going to offer opposing counsel the opportunity to argue the very same point. So if I'm to the valuation questions that I just discussed to you, A, valuation with an ADU, which we do not have here, and B, the valuation of the property regarding a workshop.
Well, then I would ask that his testimony be limited.
It's not signed under penalty of perjury as it relates to rate. We know he's going to testify because he's on the list and discuss when he's going to testify. Mr. Stern is going to testify. So the question then becomes, because defense counsel was not put on appropriate notice as to rate and other elements of bias, because that's what rate gets to, right? Whether he's being paid a lot or paid a little, I'm going to give defense counsel the opportunity to make inquiry in addition to the substance and standard bias questions that he would present. I'm going to give him additional time to inquire regarding the credibility, right? We're talking about impeachment elements. So you have, and it's, I will not cut you off as it relates to impeachment elements. Because counsel otherwise did not satisfy the statutory code. And so that's defense motion to eliminate number one. And I'm sure everybody's happy at this point. So now we're gonna move to, I have here what's described as plaintiff's motion to eliminate. I'm gonna do this one from the computer as I have some notes.
And this is plaintiff's motion number one.
Number one. So I invite you both to come to the electronic record if you wish. It's titled "To Exclude Speculative and Unfounded Testimony of Defense Expert Raymond," and it includes a declaration from Mr. Park. So the essential kind of thrust of it in points 1 through 4, as I review it, is that here we have an expert who's been designated to discuss elements of drainage. And your objection is that they're all speculative because they're based on models that are not specific to
And again, Mr. Thomas, reviewing the exhibit 1